This is a brief discussion on equitable mortgage. What is an equitable mortgage? An equitable mortgage is one which lacks the proper formalities, form or words or other requisites prescribed by law for a mortgage, but shows the intention of the parties to make the property subject of the contract as security for a debt and contains nothing impossible or contrary to law. What are the essential requisites of equitable mortgage? Number one, parties entered into a contract of sale with right to repurchase or pacto de retro, but number two, their intention was merely to secure an existing debt by way of a mortgage. Pacto de retro sale. The essence of a pacto de retro sale is that title and ownership of the property sold is immediately vested in the vendi a retro, subject to the restrictive condition of repurchase by the vendor a retro within the period provided in Article 1606 of the New Civil Code, to wit, Article 1606. The right referred to in Article 1601, in the absence of an express agreement, shall last 4 years from the date of the contract. Should there be an agreement, the period cannot exceed 10 years. However, the vendor may still exercise the right to repurchase within 30 days from the time final judgment was rendered in a civil action on the basis that the contract was a true sale with right to repurchase. The failure of the vendor a retro to repurchase the property vests upon the vendi a retro by operation of law the absolute title and ownership over the property sold. What is the rule on the presumption of an equitable mortgage? A sale with conventional redemption or pacto de retro is deemed to be an equitable mortgage in any of the following cases, and this is provided for under Article 1602. 1. Price of the sale with right to repurchase is unusually inadequate. 2. Seller remains in possession as lessee or otherwise. 3. Upon or after the expiration of the right to repurchase, another instrument extending the period of redemption or granting a new period is executed. 4. Purchaser retains for himself a part of the purchase price. 5. Seller binds himself to pay the taxes on the thing sold. And 6. In any other case where the real intention of the parties is that the transaction shall secure the payment of a debt or the performance of any other obligation. Article 1602 shall also apply to a contract purporting to be an absolute sale as provided under 1604. Note that in case of doubt in determining whether it is equitable mortgage or a sale a retro with right to repurchase, it shall be construed as equitable mortgage. Remedy, reformation of instrument. As evident from Article 1602, the presence of any of the circumstances enumerated thereunder suffices for a contract to be deemed an equitable mortgage. In such instance, the debtor may file a complaint for reformation of the instrument in order to reflect the real intention and agreement of the parties, and, if ownership of the property had been transferred to the creditor, to similarly pray for the reconveyance of said property and cancellation of any new TCT issued on the basis of the instrument between the parties. In the case of spouses Solitarios and Torda versus spouses Hake, this is a 2014 case, the Supreme Court, speaking through Justice Velasco, states, in determining the nature of a contract, courts are not bound by the title or name given by the parties. The decisive factor in evaluating such agreement is the intention of the parties as shown not necessarily by the terminology used in the contract, but by their conduct, words, actions, and deeds prior to, during, and immediately after executing the agreement. As such, therefore, documentary and parole evidence may be submitted and admitted to prove such intention. Further, in resolving this kind of controversy, the doctrinal teaching of Reyes versus Court of Appeals impels us to give utmost consideration to the intention of the parties in light of the relative situation of each and the circumstances surrounding the execution of the contract. Thus, in determining whether a deed absolute in form is a mortgage, the court is not limited to the written memorials of the transaction. The decisive factor in evaluating such agreement is the intention of the parties, as shown not necessarily by the terminology used in the contract, but by all the surrounding circumstances, such as the relative situation of the parties at the time, the attitude, acts, conduct, declaration of the parties, the negotiations between them leading to the deed, and generally all pertinent facts having a tendency to fix and determine the real nature of their design and understanding. Thank you.